Afternoon. Welcome to this Eversheds Sutherland PROPCast. My name is Joe Geen and I'm a professional support lawyer to the real estate practice group here at Eversheds Sutherland. So today's topic is understanding overage. Now, as you will have seen on the invitation for this PROPCast, different people use different terms to describe overage. Throughout the session, I will be calling it overage, but you'll frequently hear people call it clawback or additional consideration. It would be interesting to know if you use or have heard used any other terms to describe overage, so please do feel free to drop those into the chat box. So, turning to today's session, we're going to start with the obvious question of what is overage, which will look at overage as a concept, why it's used, and what it generally means. We'll then have a quick look at the standard triggers for an overage payment and the main ways in which it is calculated. And part 4 of the PROPCast will then focus on one of the most important points surrounding overage, which is how you protect it and ensure that it actually gets paid. So, to kick us off, what is overage? In its most basic form, overage is a way of securing an additional payment as part of a property transaction. So, taking our example here on the slide, A sells the land to B, which is the transfer, and then in the sale contract, the parties will agree that B would pay, say, £1 million for the property, which is the purchase price. But, in certain circumstances, B can be required to make additional payments to A, and this is the overage that we see in the bottom arrow. Although this doesn't fit with the classic formula for property transaction where A and B agree a price, B pays A the price, B then gets the land, and then the parties go their separate ways. There are many commercial reasons why overage can be used, but these all do tend to boil down to one thing, which is uncertainty. So the parties will have normally agreed a purchase price, but there may be some uncertainty with one or both of them as to whether this agreed price is a fair or commercially justified value for the property. So they therefore agree that they will complete the transaction, but if one of the overage triggers occurs, the buyer may have to make a top-up payment to the seller. So it will come as no surprise that overage frequently comes up in relation to land that has development potential. This is often because the combination of a lower price coupled with overage can make the difference in allowing a developer to take a calculated risk in buying the land before it knows if it will be possible to develop it. If the development can be realized, both the developer and the original seller of the land then benefit from any resulting uplift in value. You do less frequently encounter what we call underage, which can require the seller to refund part of the purchase price to the buyer if one of the underage triggers occurs. We don't tend to see this very often, so I'll just mention it here in case you happen to come across it. Now, I mentioned on the previous slide that an overage payment may be required in certain circumstances. Now, these circumstances are called the overage triggers. If one of the overage triggers occurs, then the sale contract or overage agreement will include a step-by-step process which the parties then follow in order to calculate and deal with the payment of any overage. The 3 most common overage triggers are the grant of a planning permission, the sale of units, and a further disposal of the property by the buyer, and we're going to consider each of these in turn. When they are negotiating a sale of land, the parties tend to have a reasonably good idea of what the buyer intends to do with the land after completion. When we are talking about land with development potential, often the first thing a buyer will need to do is apply for and secure a planning permission for that proposed use or development. For example, the buyer may intend to secure a planning permission and then build a logistics hub with 20 sheds. The parties agree that in order for the project to be commercially viable, the buyer has to be able to secure the land for no more than £3 million. However, the seller could be concerned that if the buyer is able to secure a planning permission for, say, 22 sheds, then that makes the land quite a bit more valuable. so the purchase price should have been more like £3.2 million. To balance the risk for both buyer and seller and take out the uncertainty, the parties agree that the land will be sold for £3 million, but when the planning permission is obtained, they will look at whether that affects value, and so any overage should be paid. So the overage trigger here is the grant of the planning permission. We'll look at how overage could be calculated in light of the new planning permission on the next slide. So the second common overage trigger, which we have here on the slide, is the sale of units. Again, taking our logistics hub example, the developer would buy the land and build all of the sheds, but the overage would only be triggered and payable when the developer started to sell off the sheds. And in our example, the first trigger may be the sale of the 21st shed. And this allows the buyer to avoid paying any overage until it has developed and begun selling off units. Normally these are houses, flats, or, as in the example, sheds. And this has the added advantage for both the seller and the buyer of knowing that at the point the overage is due, the buyer will have cash available to actually pay it. There's obviously the risk that the buyer never sells any of the units, but this is a commercial risk that has to be considered by the seller as part of the overall picture, which would include good faith covenants, as well as contractual obligations in order to maximise the number of sheds included within the planning permission. The third and final overage trigger we're going to mention is a further disposal of the property by the buyer. This is usually known as anti-embarrassment overage. A concern of many property companies is that they sell the land today for what they think is the correct value, but the buyer sells it on a week later for a massively increased figure. This is not only important financially, but it looks bad reputationally, hence this being called anti-embarrassment overage. For banks and receivers, selling at an undervalue can have even more significant implications where they are under a duty to get a good price on the enforcement of a charge. The trigger for this type of overage is where the buyer disposes of the property to a third party. Now obviously this raises the question, what is a disposal? And this is a point for negotiation between the parties, but it is always the transfer of the freehold interest in the land, and normally the grant of a long lease. Occasionally the overage will kick in if the buyer grants a charge, but this is less frequently seen as it can cause difficulties with the buyer's financing arrangements. Anti-embarrassment overage works in two ways. Firstly, it may disincentivize the buyer from flipping on the property for an increased value, as that value may have to be shared. Secondly, if the buyer does proceed to dispose of the property, then the seller gets an uplift in the consideration. So it's not all bad. Having had a look at these three overage triggers, just before we go on to think about how overage is calculated, I wanted to mention one point which is really inseparable from the triggers, and that is the overage period, which has been agreed by the parties at heads of term stage and then included in the normally sale documentation or overage agreement. To trigger any additional payment, the trigger event will have to occur during the overage period. With anti-embarrassment overage, this tends to be around a year. With overage triggered by planning, the overage period is normally a bit longer to allow sufficient time for the buyer to prepare, submit, and then get a response on the planning application, and often appeal any adverse decision which they receive from the local planning authority. Typically, this is going to be a number of years. With overage triggered by disposal, this can be even longer, as the development could take a long time to deliver. Discussions of the overage period are always going to be a key part of negotiations, as the buyer will usually want to get on with its development of the land, and the seller will want to make sure that the buyer doesn't just sit out the overage period to avoid any additional payments. So, turning now to the calculation of overage. There are numerous models that can be used to calculate any overage that may be due. Often, the calculations will include a consideration of the open market value of the property. And this is to ensure that if the property is sold for anything less than the fair open market value, the seller is not prejudiced by receiving a smaller amount of overage as a result. The most straightforward calculation tends to be in relation to anti-embarrassment overage, where the seller will expect to receive a fixed percentage of any uplift in value of the property. The parties will subtract the amount the property was originally sold for from the figure for which the buyer is now selling it, or the current open market value. The seller will then be entitled to a percentage of what is left. So that one is relatively straightforward. The approach taken on overage linked to planning permission can take a number of forms. The first way is quite similar to anti-embarrassment, as it is based on the amount the value of the property has increased as a result of that planning permission. As the buyer will have spent a considerable amount of money on legal and planning fees in order to secure the planning permission, the overage calculation will normally factor in these legal and planning costs by deducting them from the increase in value before the overage percentage is applied. The second way is to calculate overage by reference to the planned development. So to take our shed example earlier, when the parties had done a deal based on an anticipated planning permission to allow 20 sheds, when the buyer secures planning permission for 22 sheds, the overage may provide that the seller is entitled to a fixed amount of overage for each additional shed above 20. And of course that will be a point for negotiation, whether that's 20, 30, 40, £50,000 or whatever figure they come to. So these are the most straightforward ways of calculating overage, but there are a myriad of weird and wonderful ways that it can be done. So one point I would just mention is that if you're negotiating a more complex form of overage, it is often worth involving your lawyers at heads of term stage so they can help draw out any additional points. It may be worth agreeing at that point rather than delaying negotiation of these issues until the sale contract comes to be negotiated. So when it is included within a sale contract, overage is only a contractual obligation between the original parties. What this means is that the overage does not bind or run with the land, so anyone who buys the land from the original buyer will not be bound by the overage provisions. If the original buyer disposes of the land and sometime later overage is triggered, there might be the option for the original seller to sue the original buyer. However, if the original buyer was an SPV or doesn't have much in way of assets, this course of action might not really justify the legal spend. So it's essential to make sure that the obligation to make the overage payment actually binds any successors in title who take an interest in the relevant land. And that way, you know that you can always sue the person who is holding the land at the time, and that they will at least have the land as an asset, so it makes suing them hopefully worthwhile. And now, in this section on this slide, we're going to review the main ways of making sure that overage obligations bind the land. There are other methods of protecting overage payments, which you might hear mentioned. These are things like a long lease, rent charges, seller's liens, option agreements, conditional contracts. I did want to mention these here just for completeness, but due to time constraints and the fact that they're not really the usual way of protecting overage, I'm not going to go into any detail on these, and we'll just stick with the three main options that we come across in practice, which are the three methods we have here on this slide. From a seller's perspective, the legal charge method is the preferred method for ensuring that a property is bound by the overage provisions. This would be registered against title to the land and gives the seller an ability to enforce any overage liability against the land in a similar way to when a lender lends money which is secured against the property. However, this is often unacceptable to buyers if they're borrowing money from a lender in order to finance their purchase of the land, and this is because both the seller and the lender would want their charge to have priority over the other, and will often regard this point as a deal breaker. The reality is, the seller wants to sell the land and the buyer wants to buy the land. So of course, we look for a compromise, which is normally the next method. So method 2 is the most regularly encountered way of ensuring that overage remains enforceable against the original buyer's successors in title. The buyer takes on an obligation to secure a deed of covenant from anyone it sells to, confirming that the successor will comply with the overage provisions. the deed of covenant is given by the subsequent owner directly to the original seller. The seller ensures that this happens before, say, any transfer of the land can take place by registering a restriction on the title to the property. So unless a deed of covenant is provided, the restriction will prevent registration of the onwards transaction, which will create a huge issue for that successor in title. The added advantage of using this method, and this is from a seller's point of view, is that it flags whenever the buyer disposes of the property, as this is often the trigger for payment of the overage, so they know that they need to pay attention, and this is the point at which they need to be looking at whether any overage is payable. As with the first method that we considered, so that was the legal charge, there can be issues where the original buyer is using lender finance in order to fund its purchase. This is because it is rare for a lender to be willing to give a deed of covenant, and there is a real risk that if the lender were to enforce its own charge over the land, and say sell the land or transfer it to a third party, the third party would take that land free from the overage provisions. Again, we look for a compromise, and the compromise which we usually get to around this point is that the lender will not covenant to itself make any overage payments, but it will covenant to secure a deed of covenant to anyone it transfers the land to. And this means that the chain of deeds of covenant is kept alive even when a lender enforces its security. So the final method we're going to look at for securing overage is the registration of a restrictive covenant, and this is on the title to the property. This seeks to prevent the buyer from using the property for certain purposes without obtaining a release of the covenant. The seller would then not release the covenant unless the relevant overage has been paid. So, for example, the restrictive covenant could state that the land cannot be developed unless the overage has been paid. So if a subsequent owner wishes to develop the property, it obviously needs to secure the release of the restrictive covenant. There are some inherent issues with using a restrictive covenant to protect the overage. These include that the seller would have to keep hold of a bit of land nearby, which should benefit from this covenant. Often this won't work because the site will be sold as a whole, so the seller doesn't have any other land nearby. There is also case law which states that a restrictive covenant used to protect overage may not be enforceable at all. And as with any restrictive covenant, they are vulnerable to being challenged through the courts, and this is under statute, which is Section 84 of the Law of Property Act 1925. The detail of these vulnerabilities does obviously go beyond what we're discussing on this PROPCast, but due to the issues surrounding the method of using restrictive covenants to protect overage, and the fact that there is a greater chance of having to get involved in costly litigation compared to the other methods, we don't tend to use it or see it come up that much. So, that is the final slide that I was looking to cover on this session, and it takes us through a very quick introduction to overage. Now, as mentioned at the outset, I'm going to be staying on the line to answer any outstanding questions. And we just had one come through, and this is from Mark, who's asked, can one use multiple payment triggers, and is this seen regularly? Well, yeah, Mark, absolutely. The thing about overage is it tends to be very simple sometimes and very complex other times, and it will be very deal dependent, but you can have multiple payment triggers. So you can have a situation where you have what we call rolling overage, and what this means is that you might have, say, one or two triggers, say the disposal of different units, and each one of those will be an independent trigger for overage. Alternatively, the other way of looking at multiple payment triggers could be you could have overage which is triggered when either a planning permission is obtained or the site is sold. So you can do it in many ways, and it's often very deal specific, and it looks at what the parties have got plans for the property and how they need to secure that value. We've got another question which is asked, is there a difference between overage and clawback? Not normally, no. They tend to be the same thing. Admittedly, people will sometimes use them in quite specific ways, but overall, overage and clawback are pretty much the same. So, unless anyone else has any questions, obviously this session has been recorded, and a link to the recording can be found on the web page. If you do have any requests for topics for further sessions in the PROPCast series, or if you would like any training on topics for your teams in particular, please do get in touch. Thank you very much for joining the session. As I said, I'm going to stick around for another few minutes in case anyone else has questions. I'm just seeing a couple come in. Otherwise, thank you very much for joining. So, just to deal with those final questions, we have a question from Debbie asking, is it possible to change an overage period, say reduce from 20 years to a lesser term, or change the scale of overage to a lower amount over time? Yeah, Debbie, absolutely. So in terms of changing an overage period, what you will tend to have is obviously one period will be agreed at the outset, and then if the parties change their mind later, or say the plans change for the property, then the party who is subject to the overage may approach the benefiting party and say, can we change the overage term? Perhaps they want to sell the land on free from the overage, or they can't get finance. Now this would normally be a point for negotiation. The obvious question that a sort of benefiting party would ask is, we can change it, but what's it worth to me to do that? And then in terms of changing the scale of overage to a lower amount over time, yeah, again, we can do that. So you can have stepped reductions in, say, the overage percentage, and you can work in all manner of weird calculations which can give you a bit of a gradiated decreasing overage over time. We've then also got a question that's come through from Jane saying, if there is a transfer from the original purchaser to a new owner, but that new owner was party to the original deed, does the new buyer still have to enter into a new deed? Okay, that is a very interesting one. So what we're looking at here, I suppose, is if you had a chain of ownership, perhaps the original seller sells to buyer 1, buyer 1 sells to buyer 2, and then buyer 2 sells back to buyer 1, which, Jane, I think that's the point you're looking at, but please do message if not. It'll all depend on the drafting in your sale documentation, your overage agreement, to see whether there is a actual release, because the classic position would be that the parties will remain liable to pay the overage unless they are released. So this goes back to the point I mentioned at the beginning of always having an option to sue the original parties. But we'd say that often a buyer, so a person who is buying subject to the overage, will say that they would like to be released once they dispose of the property themselves. So this is to stop them becoming liable for anything that people further down the chain do. So normally, I would say the default is you would expect that buyer 1 who's coming back in to give a deed of covenant, but that would be something you'd have to check in the documents. Rob, do you have any examples of where developers have used clever ways to avoid paying overage? Well, there are very clever ways of doing it. Now, what you do tend to get with overage provision is there'll be an obligation of good faith. So, speaking from a seller's perspective, you always want to make sure that the overage is drafted as tightly as possible so you can avoid any of these loopholes to get around it. You know, potentially they happen. If perhaps one is found and then cynically exploited, that you could have an argument to say that they had breached the obligation of good faith. But the problem with that is it's a very wishy-washy concept. So it's not the thing that ideally you'd want to rely on, but you may have an option to do it, but obviously that'd be a point for litigation. Usually people will wait out overage or enter into negotiation. So if a person owns a property which is subject to overage and say their plans have changed, they thought previously that they weren't going to sell the land on for 10 years, but now they're looking to do it sooner, so any sale they do make would be subject to overage. I suppose they would have to look at the commercial value. Does that change their plans? And if they absolutely had to get it released, then they would normally go back and it would be a point of negotiation. But there are many different factors coming in here, so I wouldn't want to take a broad brush approach. But in terms of examples of clever ways, I haven't got any obvious ones, which I suppose is a bit reassuring. So, a recent case of attempting to avoid overage by not selling the final house on a development where overage due when all properties were sold. I mean, that's an example given by Kathy. Thanks for that, Kathy. So there you go. That would come down to reviewing the drafting and seeing where they go from there. So a good example there. Oh, apparently that didn't work, though. Oh, well, never mind. So, unless anyone else has any questions, of course, my details are here on the final slide. So if you do get any burning questions this afternoon, please feel free to drop me an email. Otherwise, thank you all for listening.